I've just added very few points to what my line says. First, Your Honor, the application is stated to have been brought under Section 49(1)(f) of the Constitution. And, Your Honor, Article 49, subsection 1, letter H says, the rights of the accused could be to be released on bond or bail on reasonable conditions, pending a charge or trial, unless there are compelling reasons not to be released. Therefore, Your Honor, the prayer number 2 is for an order of custodial order for a period of 30 days. And it is anticipated that that section applies in a case of a situation where a person has not been charged. And therefore, that's why it brings in Article 50. Secondly, Your Honor, the expression, unless there are compelling reasons, has been discussed by the Court of Appeal. First of all, in the respondents' list of authority, there's authority number 10, Criminal Appeal number 113 of 2018, Michael Juma Onyango and other versus Republic. There's a discussion of comparing reasons. And Your Honor, the second case is in a supplementary list of authority which the defendants have, the respondents have found. I have a copy, Your Honor can pass on both the principal bundle of authorities and the supplementary one. I need not to read at this stage the authorities. Authority number 10 in the principal list and authority number 1 in the supplementary list. And Your Honor, the test with the court applies is to say whether there was compelling reason for not releasing a person on board. The suggestion, Your Honor, is that when it comes to determining compelling reasons, it is only the prosecution should be had. That, Your Honor, amounts to contravening Article 50 of the Constitution. I therefore urge the...
You referred me to two authorities. Authority
number 10, yes, and
on the principal list?
Yes, and on the comparing reasons, Your Honor, comparing reasons must be shown why the bail should not be granted. And that's, Your Honor, the issue raised by prayer number 2. And when the court is determining whether they are comparing reasons, it must hear both the evidence of both the applicant and the respondent, and also hear the legal reasons of both the applicant and the respondent. Here, the applicant does not wish to permit the respondents to be heard on the evidence on which their liberty is to be deprived for 30 days. I therefore urge the court to allow the application.
You know, I know it's as a matter of practice, we don't talk after senior counsel makes submissions.
I want to maintain that practice. So I would ask Mr.
Well, it's just a correction which I wanted to make for the record purposes.
Yes.
I had earlier submitted that Section 33 is not referred to,
Yes.
but indeed what I meant, I think it was an error in my notes, the application is not based on paragraph G and H of Article 50, Article 49.
That was not submitted. That was not submitted.
Very well. I'm just saying
That will reopen and
very well. Very well.
Yes.
Yeah, but the court will have a look at the application. It is not based on the operative clause of the Constitution.
Talks about Article 52K applying only to accused persons. Forgetting that this fair hearing provisions in the Constitution starts at Article 51, that every person has a right to a fair hearing, which rights is non-derogable as provided under Article 25. Your Honor, when the police seek to use an extraordinary process under Porter in Section 33, extraordinary because that particular process is used to go around the provisions of Article 49, the right to bail. When the suspect is brought before you, he is either supposed to be released on bail or charged. Here you're being told, no, we are not ready to charge them, but do not release them. That is an extraordinary process that is protected. In the affidavit before you are the purported reasons, the compelling reasons to allow the court to hold the suspects for a limited time, or it's 14 days, 21 days,
30 days.
30 days, sort here. Under Section 33, Section 5, compelling reasons must be provided. These are the compelling reasons that must be tested. Otherwise, the accused person will never have a chance to challenge that. The suspect will never have a chance to challenge that evidence contrary to his rights under Article 50, the whole of Article 50, not just Article 52. Okay. The right to a fair hearing includes the right to a fair trial.
Your Honor,
Your Honor, that allows us, as it were, to test the veracity or otherwise of the statements, both of fact and law, as they point to in the affidavit before you. And secondly, I'm just looking at the jurage. If Mr. Machira suggests that the IO needs to prepare, at paragraph 20, and this is common with all affidavits, the deponent on oath states that all the matters that have been deposed to are true to the best of their knowledge, and except for matters that they point to sources of information where they have disclosed. These are the sources that you want to test. The truth that he deposed to is what you want to test. And Your Honor, an affidavit is evidence. Affidavit is evidence presented before court, either on affirmation or on oath. We want to test that evidence. Please be persuaded by those few